Hey everybody, hope you're doing great today. In today's video I want to talk about dual agency when it comes to real estate transactions. So with a dual agency situation, I as a real estate agent am representing both the buyer and the seller. So for example, I've got a listing on a certain property. Buyer happens to come to me. They either visit the property during an open house or they contact me personally and say, hey, we're interested in this house. I want to take a look at it. And then they like it and they want to put in an offer on it. So they are not working with their own agent. They figure they might be able to save a few bucks by working with me directly. So they want me to put in the offer for them. So in the state of Ohio and the state of Kentucky, I can work as a dual agent, as a real estate agent. Now I'm also an attorney too, and many of our ethic rules and legal rules with regards to attorneys prevent us from doing something similar to a dual agency. So while I'm an attorney, I'm not your attorney. And when it comes to representing both sides on a legal matter, it's prohibited in most cases. So for example, a divorce attorney can't represent both spouses in that situation because there is an inherent conflict of interest. So when it comes to dual agency, it can be very tricky too. So when I'm representing just one party, I owe my entire duties just to that one party. So the example of a seller, I have a listing with them and I'm just representing them. So if I happen to learn something on the buyer's side, basically that they're pretty desperate to buy a house for whatever reason, say for example, they just sold, they need to move quick, and they've got kids they want to get in school at a certain time. So they're pretty much ready to pay higher than what they normally would. If I'm just representing the seller, that's information I should be sharing with the seller. Now, if I'm in a dual agency situation, I should not be sharing that information with the seller. Or if I'm representing just the buyer, I should not be sharing that information with the seller. Similarly too, if I'm representing the buyers and I happen to find out information that sellers are having issues, for example, they're getting divorced, they need to sell the house, each spouse on their own cannot afford the house, they want to sell it now, get out of it, split the proceeds, and head their separate ways. In that case, if I find out and I'm just representing the buyers, I can share that information with them. Again, if I'm as a dual agent, I do have to step back and not do that. From a personal standpoint, I try to avoid dual agency because there is that potential conflict in there. I've had situations in the past where I've listing a property, a buyer comes to me and says, hey, we're interested in the property, they don't have their own agent, they want to buy it. So usually when I write up my disclosures, I'll state that I'm just working for the seller. I confirm with the buyer they're comfortable working on their own, they don't need their own agent. Write it up that way in the disclosures that the buyers and sellers must sign, and then proceed from there. As part of these real estate transactions, many states have agency disclosure laws. And basically that's a couple-page form that shows how each agent is acting in terms of who they're representing. So if it's a single agent, that agent needs to state whether they're representing just the buyer, just the seller, or both. Versus if there's two agents, it needs to be disclosed who the agents are representing. For example, if I were representing the seller, on the disclosure form I would be saying, I'm the real estate agent, this is the broker, and we're representing the seller. So the disclosure forms are a must. Now there are a few states that prohibit dual agency. So basically if a buyer comes along, says, hey, I want to buy your listing, you're the listing agent, in that situation the agent cannot act as a dual agent in those states. So for the state of Ohio, the state of Kentucky, it is allowed. Your own state may have different rules, and you need to check with your local state regulators to find out what their rules are with regards to dual agency. Whether you are a buyer or a seller, I would always recommend having your own agent. It's just better that way. You've got that one person that's devoted to you, looking out for your best interests. Whereas if you enter that dual agency situation, that agent has to kind of step back, be neutral to both sides as best as they can, and then proceed from there. So to show some of the problems that can arise with dual agency, I'm going to look at some of these disciplinary cases that happened here in Ohio from 2024 and 2023. Just go over these quickly and kind of explore what went wrong, what was done, and what sort of fines or punishment were given to the agents who did practice this dual agency. So here we can have a case from April 2024. This is a broker who was ordered to pay a $3,500 fine. The license was suspended for 30 days, and they were ordered to complete 3 hours of additional education in core law and to complete the 10-hour post-broker course. They probably already completed that course in the past, but they're being required to redo that course. So they note the broker was ordered to complete this discipline for failing to be loyal to her clients, the sellers of the subject property, and remain neutral in the transaction. So the particular code section they cite here states, in representing any client in an agency relationship, the licensee shall be a fiduciary of the client and shall use the licensee's best efforts to further the interest of the client, including but not limited to doing all of the following. Specifically, they call out performing all duties specified in this chapter in a manner that is loyal to the interests of the client. So when you get that situation where you're acting as a dual agent, my question is, how can one necessarily be loyal to both sides? And hence my preference for not engaging in dual agency and just working with one particular client. So another big mistake that this broker did was they acted as a dual agent where they were also a party to the transaction. So that's a big no-no for brokers and agents. Basically, if I'm interested in buying the property and I'm also the listing agent and I make an offer, I could get into trouble for that. So that's something agents and brokers should not be doing. Now, if it happens to be a property that I don't have listed, maybe not listed, it's for sale by owner, another agent has it listed, yes, certainly I can go and make an offer on that property. I do need to disclose that I am a real estate agent under the law. And similarly, if I'm a real estate agent and I'm selling my own personal property, whether I'm selling a house or I'm selling investment property, same thing, I also do need to, under the law, disclose that I'm a real estate agent and I'm selling this property. So in that situation, if I'm selling my own property, I would not be representing any buyers in that situation. I'm prohibited from doing that, and that needs to be disclosed up front. Also notes that the broker failed to understand that she was a dual agent in the transaction because she was personally involved in the transaction and failed to have another management level licensee affiliated with her brokerage work on that deal. So while most of these cases note that there's fines been paid, license suspensions, additional education, that's strictly what the state is imposing. There is always the risk that these agents and brokers can also face civil liability. So in this case, the seller could sue them if they were also representing a buyer in a certain situation where the dual agency went bad. Buyer or the seller can sue them. There's another case where a broker was ordered to pay a fine of $1,800, complete some additional education. They note here this is a violation of this particular code, creating an illegal dual agency when she submitted a bid to purchase one or more parcels of the subject property on her own behalf, while she and her brokerage continue to represent the seller of the subject property. So same thing as in prior, she needed to not be representing this property owner. Then, if she had purchased this property from them and was not representing them, wouldn't have had the issues she's having here right now. There's another case, a salesperson was ordered to pay $1,000, and in this situation, it was more about the lack of timely disclosure. So as we see here, the agency disclosure for this dual agency transaction was signed by the buyers on June 1st and signed by the sellers on June 3rd, basically 1 day and 4 days after the sales contract was signed. The Ohio Revised Code here states that the requirement is the licensee must present the agency disclosure statement to the buyer and request the buyer sign and date the agency disclosure statement no later than at the preparation of the offer. So once this agent was preparing the offer, that's when they should have given the agency disclosure statement to the buyer as well to sign. The fact that they didn't do that caused her to get in trouble. In this case, from 2023, we see an example where an agent was the only one involved in the transaction, but he failed to indicate on his agency disclosure statement how he was representing the parties in the transaction. So that's a no-no as well. He didn't state whether he's just representing the sellers, he's just representing the buyers, or representing everybody. Make sure that's disclosed, let everybody know, and then have the agency disclosure document signed accordingly. So here's a case where a agent had his license revoked, number of fines, number of education hours, because he did not disclose that he was a dual agent and he was representing the buyer and had interest in the buyer offer. So here it shows what the misconduct was. It states, during the dual agency representation, he disclosed confidential information to the prospective buyer, who happened to be his stepmother, and based on text, he texted information related to acceptance or non-acceptance of our offer, quote unquote, and described the seller's family circumstances. So as I mentioned before, if I happen to be representing the buyer, I find out the seller is divorcing or they need to sell because they need the money for XYZ, and I'm also representing the seller, but I didn't disclose I'm representing the buyer, as in this case was. That's where the trouble arose, and this agent found himself suspended. So the entire concept of dual agency is a tricky one, and from my personal perspective, coming as an attorney I am prohibited from representing both sides on a transaction, always recommending each side get their own attorney. Even from an agent's perspective as a real estate agent, I also do the same thing. Refer it out to another agent if need be, or let the buyer know that they'll be going in unrepresented if I'm representing the seller, or if I'm representing the buyer, the seller will be unrepresented in that situation. I go back to that statement I made earlier. All sides should have their own agent just to have their own interests protected. Ultimately, it's up to the individual buyers and sellers themselves whether they want to do that or not. So if you found this video to be helpful and informative, please hit that like button so others can find it too. Thank you for watching, and I'll see you in the next video.